Why Shamila Batohi and Cato Manor Crime Unit witnesses are abandoning the Nkabinde inquiry. The Exposition. Introduction. Recent developments in the Nkabinde inquiry indicate that the former head of the National Prosecuting Authority, NPA, Shamila Batohi, together with potential witnesses linked to the Cato Manor Crime Unit, have elected not to proceed with testimony in the ongoing proceedings. This decision, particularly Batohi's departure during cross-examination, has triggered widespread criticism across social media platforms and public forums. The central question that arises is whether these critics are sufficiently informed and whether their criticism is fair. This exposition seeks to answer that question by examining the nature and legal framework of the Nkabinde inquiry, with reference to the National Prosecuting Authority Act, the Mogoro inquiry, and relevant media reports. Disclaimer. The comments and criticisms expressed here are not intended to discredit the evidence presented before the inquiry or the integrity of the inquiry panel. They are advanced solely to express concerns about aspects of the process adopted.
As evidence leaders, we received a message from the NPA team that Advocate Batohi would like to be excused from these proceedings to go and seek legal counsel.
Chairperson, I wasn't seeking permission. It's something that I decided I needed to do because it is about me and my integrity.
So you can do whatever you want without approaching us.
Chairperson, I didn't want to come here because I did not want to be subjected to this kind of questioning. I would appreciate it if I can be excused now.
What is the NPA inquiry? The Nkabinde inquiry is established in terms of Section 12(6) of the National Prosecuting Authority Act. This provision empowers the President to provisionally suspend the National Director of Public Prosecutions or a Deputy National Director, pending an inquiry into that person's fitness to hold office. Such an office bearer may thereafter be removed for 1. Misconduct, 2. Continued ill health, 3. Incapacity to perform official duties efficiently, or 4. No longer being a fit and proper person to hold office. It is important to emphasize that the Nkabinde inquiry differs fundamentally from commissions of inquiry such as the Zondo Commission or the Madlanga Commission. The latter are established under the Commissions Act and enjoy subpoena powers. In those proceedings, witnesses may not simply withdraw without completing their testimony. By contrast, the Nkabinde inquiry is constituted under the NPA Act, and participation is voluntary. This distinction was clearly articulated in the Mogoro Inquiry Report, which stated, "The inquiry did not have the power to compel witnesses to provide evidence or testimony. A Section 12(6) inquiry is not imbued with subpoena powers. Information placed before the panel came from individuals and institutions volunteering to do so." Accordingly, Batohi was not legally obliged to continue testifying. Suggestions by Advocate Nkabinde that she might face adverse consequences, similar to those faced by Mr. Jacob Zuma at the Zondo Commission, are, in this context, misplaced. Zuma was subpoenaed by a commission with coercive powers. Batohi was not. The Nkabinde inquiry and the Mogoro inquiry. The Nkabinde inquiry bears procedural similarities to the Mogoro inquiry. In both processes, the terms of reference required the panel to have due regard to all relevant information, including, but not limited to, matters relating to the Richard Madluli case and the Johan Boysen matter. However, this latitude does not render the inquiry limitless. The relevance of information must still be assessed against the defined terms of reference. Rules and evidence. The rules of procedure applicable to the inquiry were drafted in the context of an administrative inquiry, not a commission, disciplinary hearing, or criminal trial. As the Mogoro Inquiry Report explained, the procedures adopted were therefore inquisitorial as opposed to accusatorial. Furthermore, unlike a court of law, where evidentiary laws regarding admissibility apply, the inquiry was not subjected to the same constraints. This allowed the admission of a wide range of material, including affidavits, court records, case dockets, official reports, and memoranda. Nevertheless, the principle of relevance remains central. Evidence admitted must relate to the inquiry's terms of reference. During cross-examination, Advocate Chalk's legal team introduced material relating to other cases involving the Cato Manor Crime Unit that were unrelated to the registered Madluli and Boysen matters. In my view, this evidence fell outside the scope of the inquiry. The inquiry panel ought to have disallowed such material, and the evidence leaders should have objected on the grounds of irrelevance and prejudice. Batohi was confronted with this material without adequate time to consider or respond, resulting in procedural unfairness, allegations, and proper procedure. If Advocate Chalk genuinely believes that Batohi engaged in wrongdoing, the appropriate course would have been to submit a formal complaint to the president. Batohi appeared before the inquiry as a witness, not as an accused person. The use of cross-examination tactics that effectively placed her on trial amounts, in my opinion, to an abuse of process aimed at discrediting her, rather than advancing the inquiry's mandate. As I understand the cross-examination process, a witness should not be questioned on matters that fall outside her evidence in chief. It is therefore unclear why Advocate Chalk's legal team sought to introduce new issues for Batohi to answer. This approach was procedurally improper. It bears mentioning that Advocate Chalky would still have had an opportunity to present his own evidence in due course. General Johan Boysen has similarly criticized this approach, describing it in media reports as self-serving and an attempt to deflect attention from the real issues under scrutiny.
2004, I witnessed torture at the Cato Manor office.
It doesn't actually involve actions on your part, but I'm trying to understand why the National Director of Public Prosecutions would have walked out of the Nkabinde inquiry, illegally, when this email came up, and what would have made her, I suppose, so scared for her own legal position. She had to seek personal legal advice.
Stephen, I think you are perhaps seeing something that's not there. I don't think she was scared. I don't want to sit and defend Advocate Batohi, and I don't want to disrespect the Commission. I'm going to leave it at that. But I think if you watch the way she had been cross-examined over a period for probably about 2 weeks, I'm not going to say it was hostile, but yes. Anyone who watched that can go and watch the entire cross-examination and decide for himself why they suspect she might have left. I can assure you, without any shadow of a doubt, there's absolutely nothing untoward about that particular email. Stephen, I just want to go back slightly. That Danica alleges that I've been harassing him. I think the converse is actually true. He's been carrying on about this issues of his since he left South Africa. I think it was in 2008. And he's been continuously on different fora, and he claims to be a whistleblower, and he calls meetings, and he engages with people in South Africa. And he continuously, on webinars, make these allegations, which have been proven to be untrue over and over again. So I think the converse is true, that he's the one that's actually stalking me. By every time he gets an opportunity on whatever forum, whistleblowers forum, or whatever the case may be, to falsely accuse me. Stephen, let me be very clear. Let me say for once and for all, there were 3 statements in 23 dockets. None of those remotely implicate me in...
Cato Manor Crime Unit witnesses. Against this backdrop, it is understandable that potential witnesses linked to the Cato Manor Crime Unit may be reluctant to testify. The aggressive and arguably unfair cross-examination of Batohi signals a risk of prejudice to witnesses who are not themselves the subject of the inquiry. Such tactics do little to assist the inquiry in fulfilling its mandate, and may instead undermine its credibility and effectiveness. Why Batohi left halfway? Based on the foregoing, it is my view that Batohi's decision to leave the inquiry was driven by emotional distress arising from what she perceived as an ambush during cross-examination. Her reaction, while human, was ill-advised. I do not condone her decision to depart without first lodging a formal application to be excused. Nonetheless, her conduct should be understood in context. It was not an act of disrespect, but rather an emotional response to a procedurally troubling situation. The way forward and conclusion. In my assessment, the Nkabinde inquiry process remains redeemable if the panel adopts the following corrective measures. 1. Strictly focus on issues within the terms of reference, particularly the specified cases. 2. Refer any new complaints or evidence falling outside the scope of the inquiry to the President or an appropriate forum. 3. Clearly inform witnesses of the issues relevant to their testimony and formally request their participation. 4. Consider accepting written statements in lieu of oral testimony, thereby avoiding adversarial cross-examination. 5. Adapt means and practices that will promote a speech and cost-effective inquiry. Both latter approaches were successfully utilized in the Mogoro inquiry, where the panel received affidavits from witnesses who were not called to testify orally. The inclusion of affidavits and transcripts from witnesses such as Angelo Agrisi, originally provided to the State Capture Commission, demonstrates the practicality of this method. Adopting such measures would not only safeguard procedural fairness, but also conserve time and public resources, ultimately strengthening the legitimacy and outcomes of the Nkabinde inquiry. What are your thoughts about my analysis and comments made in this documentary? Please share your thoughts in the comments section.